Hello, you all. Daniel Sherman again. Happy Valentine's Day. My son's academic team has a little bit of a lunch break, so I'll have a chance to talk to you guys about arraignments. You'll be proud of me. I'm not driving. I'm stationary, sitting in the parking lot of Hopkins County South Middle School, waiting for the academic team meet to commence. So I want to talk to you all about arraignments. And one of the favorite movies of any lawyer has to be My Cousin Vinny, and there's a famous scene in there where Vinny doesn't understand what an arraignment is, and the judge says, I only want to hear, one of two words, guilty or not guilty. That is it. So that is the point, at least the initial point of an arraignment, is a defendant does have the ability to enter a guilty plea. If not, the court will enter a not guilty plea for that defendant. Kentucky works a little differently than some states because most felony cases actually start off in district court, and district court does not have jurisdiction to dispose of felony cases, so the court will automatically enter a not guilty plea for that person. Only after an indictment will the individual be able to enter a guilty plea to the court. So that's the first purpose of the arraignment. The second purpose is to determine whether or not that individual is going to be in need of appointed counsel. Obviously, if the defendant shows up with a hired or private attorney, that individual, doesn't need the appointment of an attorney. Then you get some people that don't want to hire an attorney, and they may have some funds to hire an attorney. So the court is required to make a determination whether that person lacks sufficient financial resources or assets or income to retain an attorney. Now, the defendants are supposed to fill out an affidavit of indigency and submit a formal application before the court. I will tell you that does not happen very often. It's a lot of paperwork, and it's usually when somebody comes up, they're in jail, even if they're on a small bond and they haven't posted it, obviously they can't afford an attorney. So the courts do, I think, probably a service to the community, moving it forward and not requiring the affidavit of indigency. But I will say there's some times where, a person comes in, they've posted a $5,000 or $10,000 bond, and the court looks at them and is like, why are you not hiring an attorney? If you had $5,000 or $10,000 to post bail, you probably have some money to hire an attorney. And so that's kind of where the area gets a little more murky. You will, I have seen judges say, listen, you need to go and, assign this bond, or you need to sell some of your property, your car, or take a lien on your house or whatever, to hire this attorney. So that does happen. It doesn't happen very often. Courts usually err on the side of caution when appointing an attorney. Now, the court can assess a public defender's fee, and I'll say that I've seen courts assess, the highest I've seen in Kentucky, and I think it's the max, is $1,250, for individuals that do have jobs, and that'll kind of offset some of the costs that the public defenders go through in representing individuals. So now somebody can hire a private attorney, ask for the public defender if they qualify, or they can represent themselves. Representing themselves does not happen very often, but there are individuals that legitimately want to represent themselves. You're allowed to represent yourself, but the court is required to conduct a Feretta hearing. Actually, there's a published case that I had. It was the first criminal case I ever did, and it was the first appeal I ever did. It's a published opinion regarding a judge who took away my client's attorney shortly before the trial. Said, hey, you need to go hire one, and he couldn't hire one because he was in jail, and they tried the case. He was convicted, and then the Court of Appeals reversed and said, no, you gotta appoint him an attorney, or even if he's going to represent himself, you have to conduct a Feretta hearing. And that FREDA hearing, basically, you have to make sure that the defendant knows the concepts, understands what they are doing, that they're giving up their right to an attorney, that they're going to be subject to all the rules normal attorney is. They're not going to get special treatment, and to make sure it's something that they're wanting to do. I've seen a lot of cases where if that does happen, the court will go ahead and appoint a standby lawyer. I see that more in federal court. I don't say I've seen it too much in state court. I did have one about a year ago. Somebody wanted to represent themselves. I was doing contract work for the DPA, and he wanted to represent himself, and then ultimately he decided to, that's maybe not a good idea. We were able to work the case out for him, I think, pretty favorably, and he was happy with that. So there's that. Then the next issue, guilty or not guilty, attorney, and then the next issue is bond. The court, and I'm going to address that in a different video because it's a little more complicated. I don't want this video to run terribly too long. But an individual comes up. You can there's several ways to get to court. You can be summoned to court, which is a piece of paper that says, whether it's in an indictment or just a criminal complaint, that says, hey, you need to come to court, here's your court date. You're not arrested, you go to court. The court still is required to set bail, whether it's release on your own recognizances or cash bail or anything like that. You can also have a warrant for your arrest. And a police officer, sheriff's department will come out, serve you with the indictment or criminal complaint, physically arrest you, and then take you to the jail, and they'll take you to court. Now, a lot of times on that criminal complaint, there's a bond that's set, but not always. And then the other one is, if a bond isn't set, you come in front of the judge, and the judge will set your bail right then and there. So the arraignment is really the first time you get to look the judge in the eyes, and the judge will make a decision on your bail, whether to increase it, whether to decrease it. So that is an arraignment in a nutshell. It's a little more complicated than the judge would indicate from my cousin Vinny, but all the same, the purpose is to not guilty or guilty, and then move on with the proceedings, get another date to come back, a pretrial conference, a preliminary hearing. I've been in some courts where they set a trial at arraignment, and that's just kind of the way it is. So that's an arraignment in a nutshell. Guilty or not guilty, that's all the judge wants to hear.